Court Rules Research for the Advanced Legal Research course at Boston College Law School. Court rules govern the litigation practice and procedures in the courts. The establishment and jurisdiction of most courts is governed by statute, but courts are usually authorized to adopt rules to further define their processes and procedures. Court rules exist on both the state and federal level. They set forth the procedures for initiating, defending, and appealing cases. The purpose of these procedural court rules is to promote uniformity and assist the court in conducting its business efficiently. Court rules that have been validly adopted have the same legal effect as statutes. Within a court system, there are a number of categories of rules. The first is rules of general application. These typically include the rules of civil procedure, criminal procedure, and appellate procedure, as well as the rules of evidence. Here in Massachusetts, we do not have formal rules of evidence, and courts rely on common law for most evidentiary rulings. The next level is rules for specific courts. At the federal level, this includes the U.S. Supreme Court, the Bankruptcy Courts, U.S. Tax Court, the Foreign Intelligence Surveillance Court, and the U.S. Court of Federal Claims. State courts have courts of general jurisdiction as well as courts of special jurisdiction, which are empowered to hear only cases of certain kinds. Courts of special jurisdiction will have their own rules. Some examples of state courts of special jurisdiction are family court, housing court, drug treatment court, and probate court. In addition, many courts have local rules which supplement the rules of general application and govern the specific court's own internal operations. Another supplemental procedural rule is the standing order. Standing orders can be issued by a court or an individual judge. Local rules and standing orders are subservient to the general and specialized rules and do not supersede the existing rules. There are many places to find the rules themselves. In many law firms or government law offices, especially in the litigation practice, historically individual attorneys were given a personal set of federal and state court rules. Court rules can also be found on court websites. The United States Courts website has PDF versions of the federal rules of general application, as well as the rules from many of the special courts. Local rules and standing orders for a court are often available on the individual court web page, like this page for the U.S. District Court for the District of Massachusetts. The local rules for the U.S. District Court for the District of Massachusetts are available on this 174-page PDF. For the standing order of an individual judge, check the judge's web page. The standing orders are way down on this page, but I wanted you to see the top of the page and the link to the standing orders on one slide. State websites also contain rules of court and standing orders. Massachusetts warns us that not all Massachusetts rules of court are available online, and what is here is only an unofficial version of the rules. Find court rules on Westlaw under Content Types, Statutes, and Court Rules. You can select Content Type first or choose Jurisdiction first. Westlaw treats court rules as part of their annotated codes. Lexis also treats court rules as part of their annotated codes. Find federal rules on Lexis under Federal Content USCS Federal Rules Annotated. For individual states, the court rules can be found under Statutes and Legislation, selecting that from the Lexis homepage or from an individual state's page. Find court rules on Bloomberg Law in All Legal Content under the heading U.S. Courts. You can also access an individual court's rules on Bloomberg Law by typing the source name into the universal search bar and selecting Browse TOC. Having located a relevant rule, one of the places to look for interpretive materials is to look to comments from the drafters of the rule. In the federal system, these are advisory committees of the Federal Judicial Conference. On Westlaw, advisory committee notes are lower on the page in the rule document. The Advisory Committee of the Federal Judicial Conference is made up of lawyers, law professors, and judges. They are responsible for drafting proposed rule changes, considering comments from interested parties, and writing the notes of the Advisory Committee, which, though not binding authority, do provide insight into the purpose and language of the rules. You can also find these interpretive notes in the Rules document on Lexis. Navigate down to the Notes section under Annotations. Procedural rules are frequently cited by courts, and case law applying those rules can be useful in court rules research. Because Lexis and Westlaw include federal court rules in their annotated codes, there are editorially selected notes of decisions on both platforms, as well as other editorial features available on these platforms. Cases that cite federal and state court rules can be found on the three major legal research platforms. Lexis court rules have find references to this court rule link. This provides access to citing cases and other types of legal materials. Citing references on Westlaw are part of the Westlaw Citator key site. Bloomberg Law's Smart Code also provides references to citing cases. These citators have a variety of available filters. They can also be used to validate the rule and any case law relied upon, an important step in legal research. There are also a number of treatises on court rules that can assist in developing a better understanding of the often complex court rules. Among the most respected and most frequently cited are Moore's Federal Practice, available on Lexis, and Wright and Miller's Federal Practice and Procedure, available on Westlaw. An amendment to a federal rule generally takes about 3 years. A proposed rule change is usually considered by an advisory committee and published for comment as part of a document called a preliminary draft during the first year of the process. Considered by the Committee on Rules of Practice and Procedure, the Standing Committee, and the Judicial Conference in the second year, and by the Supreme Court and Congress in the third year. The Supreme Court has until May 1st to transmit an amendment to Congress for consideration. Congress may enact legislation to reject, modify, or defer the amendment, but absent congressional action, the amendment becomes law on December 1st.